When do you have to file an amended H-1B petition? And when do you have to file an amended petition for other visa classifications? That's what we're talking about on today's Live at Lunch. My name is Emily Sumner with Sumner Immigration Law, and I'm so glad that you've joined us, whether you're joining us live or if you're catching the replay. If you have questions, feel free to put those in the comments, and I will certainly answer if I can. As always, this information is not legal advice. It's for informational and educational purposes only. So let's talk about, generally speaking, when do you have to file an amended petition for an H-1B? And I'm talking specifically about the H-1B because there's a lot of guidance around when an amended petition is required for the H-1B, both in the regulations and in policy memos from USCIS. However, the information that we're talking about today also can apply to other visa classifications as well. So certainly when we're talking about the wage or the location, things that are listed in the labor condition application or the LCA that you have to file before you file the H-1B, the LCA is also required for other certain types of visa classifications, such as the E3 and the H-1B1. So generally speaking, these requirements to file an amended petition, when we're talking about them within the H-1B context, would also apply in the E3 and H-1B1 context. Generally speaking, they would also apply within the TN context, although there's not a lot of written guidance from USCIS or even Department of State about when an amended petition is required. So let's get into it. When is a amended petition required for the H-1B? In general, an amended petition is required when there is a change in worksite. So that means, well, let me back up for a minute. In general, what the regulations say, which is maybe not tremendously helpful, but the regulations, the H-1B regulations say an amended petition is required when there is, quote, a material change in the terms or conditions of employment. So I'm just looking at the regulation to terms and conditions of employment and not work. Anyway, when there's a material change in the terms and conditions of employment. So what does that mean? It can mean, we know generally, just from logic and from USCIS policy, that means that if there's a change in worksite. So if there's a change in worksite, there are a few questions that we as immigration attorneys ask our clients when we're going through this analysis about, is there an amended petition? Is there a requirement to file an amended petition due to the change in worksite? So one question that we ask is, or what we look at is this new worksite within the same area of intended employment? That's a legal term. It's defined in the regulations, but basically it means, is it within the same MSA, metropolitan statistical area, or is it within commuting distance of the worksite location that's listed in the LCA and the H-1B petition? If it is, then generally speaking, if there are no other material changes in the terms and conditions of employment, then you just have to file, you meaning the employer, have to post the notice of filing at the new worksite for 10 days before that change takes place. So we've had situations before, of course, where an office moves. You know, our corporate client has headquarters, the employee is working at the headquarters or at their office, wherever it is, their office location, and their office moves, you know, across town or perhaps down the street. So in that situation, likely, again, you have to look at other factors as well, but likely you only have to place, as an employer, you only have to place a new notice of filing at the new worksite for 10 days before the person begins to work there. There are other situations where, another example is a person will start working from home. So they were working in the office, now they're going to work from home, or perhaps a hybrid thereof. We just have to make sure that that notice of filing, believe it or not, is placed at their home in two conspicuous locations. So yes, we have instructed clients to post the notice of filing on their refrigerator and, you know, their stove or wherever, but it is required and we want to be compliant. So that's what we do. So if it's a change in worksite that is a different, completely, you know, outside of the original area, that's when you would need an amended petition. So we have had situations where our clients the individual employees are working at client work sites, at end client sites, and they are working in Ohio, and then they change, and now they're going to be working in California. Obviously, we would need an amended petition there. Or they're working from home always, but their home is moving from state A to state B. We would need an amended petition in that situation. So we always we literally get out Google Maps and look at the mileage when we have this question. But that's what we look at is the new worksite within the area of original area of intended employment? And if so, we can probably have the client post a new notice of filing. If not, we would need an amended petition. There are some exceptions to this. Of course, there's always exceptions in immigration law, right? To make it complicated, there is a short-term placement option. So there are certain requirements that have to be met there. But basically, if the H-1B worker is going to be working at a location that's not included on the LCA, the labor condition application, for less than 30 days, then the employer may be able to use this provision in the regulations about short-term placements. Again, there are other requirements, so make sure that you talk with your immigration lawyer before you try to take advantage of that particular provision. Other reasons you might have to file an amended petition: if there's a significant change in job duties. So for example, and when I say job duties, I'm meaning the position, right? So job duties, the title may or may not change along with that. But for example, if we have somebody who's working as a software engineer and now they are being promoted to project manager, that probably is going to be a situation where they have significantly different duties, even though they may be related. And we would need to file an amended petition. So anytime there's a change in job duties, job title, if you think, I wonder if this is still within the same SOC code, which is something that we look at as immigration lawyers, and you may or may not be thinking along those lines, totally fine. But if there's a change in your job duties, absolutely have your immigration lawyer do that analysis to make sure that there is not an amended petition required. If there is a significant salary increase, so even if you're not changing your job duties, your job title, if there's a significant salary increase, you may need an amended petition. If there's a salary decrease and you're not going to be paid, or your employee is not going to be paid the amount that's listed on the LCA, then we definitely need to file an amended petition in that situation. Likewise, if there is a change in the hours. So we have had situations over the years where the individual employee is working part-time and they're switching to full-time, or vice versa. In those situations, we would need to file an amended petition. In addition, if there's a change in the name of the employer or the tax ID number, because of a amendment, because of a merger or acquisition, or for some other reason, sometimes there are business reasons that a company will change the name or the tax ID number, or business structure, whatever it is, absolutely have a conversation with your immigration counsel to see if you need to file an amended petition. You may or you may not, depending on the situation. Sometimes in merger and acquisition situations, there's a successor in interest provision that applies, and we actually don't have to file an H-1B transfer. There's paperwork that has to be done. But anyway, my point is, it's complicated. Make sure you talk with your immigration lawyer. So what are the situations where an amended petition would not be required? Potentially, if there is a minor raise, a minor change or increase in the salary or wages that the H-1B worker is being paid. And again, this information applies to other visa classifications as well. Like I said, there's the short-term location provision for H-1B workers. So if you're going to place your worker for a short time, less than 30 days at a different location, you may not need to file an amended petition. Then there's the question of when to file the amended petition. It is required that you file the amended petition before whatever change it is takes place. I know as a practical matter, I work with HR professionals all day, every day. And I know as a practical matter, it is not uncommon to find out about a change that has happened that you just weren't informed about for whatever reason. So the best time to file an amended petition, of course, is before it happens. That is what is required by law. Second best time is potentially after it happens. Talk with your immigration attorney, come up with a strategy, but you don't want a situation where you have a significant change, a material change, if you will, and you just don't address it at all. That can be problematic, which leads us into one of my final points here, which is, how does USCIS know? What if you have a material change and you don't file an amended petition? What happens then? So first is, it's a compliance issue for both the employer and the employee. You can have problems with extending the petition or filing an H-1B transfer later. You can potentially be found to not be maintaining status because you're working in a place that you weren't authorized to work. It can be a paperwork violation for employers. It can be potentially getting distracted here by messages. It can potentially be a, like I said, status problem. It can be paperwork violation. If you wanted to kind of extrapolate this and make worst case scenario, potentially like unauthorized employment. Anyway, make sure that you're compliant. And if in doubt, ask. I love it, love it, love it when our clients, whether they are the individual employees reaching out or the employer contacts reaching out to say, hey, we have this change in this person's employment. Do we need to file an amended petition or not? I'm happy to answer those questions for our clients. And I love helping clients address that proactively instead of finding out 6 months, 12 months, 18 months later that there's a significant change that nobody told us about. And so we didn't file an amended petition. So that brings us to our last point, which is if you are in a situation in which you are, which you're managing HR functions, including immigration, make sure, it's a good idea if possible, to make sure that you have educated at least the individuals that are affected by this, who need to know this. So by that, I mean managers. If you have managers, supervisors who are working with foreign national employees, make sure that they know that they should notify you if and when there is a significant change, because I've seen that happen so many times before where the manager or supervisor of a particular foreign national employee will approve a change and they don't know that it's required to file an amended petition. So they don't tell HR and HR doesn't tell us. So there's not an amended petition filed. So just a little bit of education can go a long way there. In addition, if you are responsible for overseeing immigration filings within your organization, or if you're involved in that at all, it's a good idea to have a regular review, even if it's like an annual review of your immigration filings, just to make sure that everything's aligned, to make sure that people are actually working where the LCA says that they're working, to make sure their job title hasn't changed, salary hasn't changed significantly, things like that. So I hope that you have found this information helpful. If you have, I hope that you will share this video with a friend or colleague. Make sure that you like it, drop a comment, drop a question if you have any questions, and I'm happy to help if I can. Otherwise, my name is Emily Sumner with Sumner Immigration Law. We assist clients from around the world and around the United States with employment-based and family-based immigration matters. And if you have not subscribed to this channel, please do that as well so that you don't miss our next video. I'm here, happy to answer questions, happy to have consultations if you're not yet our client, to make sure that you're on the right path for immigration. We're here to support you. I hope that you'll join us next week for our next live at lunch, next Tuesday at noon Eastern. Until then.